the attention of your lordships to it, because that will also affect whatever other steps are being taken in respect of this case. So I think we recognize that you have just given a ruling about the operation of CI 47 and how it's affected by the subsequent CI, which we will advise ourselves on once we have it. And I think that that will guide the process of our recommendations in respect of the case management. The final thing I will say is that I think, as is fairly normal, we are quite happy to set down the issues that are arising from the petition and the respective answers, and put that forward so that it is considered by council. I do not think that is a process that is easily done just on one's feet in a courtroom to try to determine what are the issues. I think that a normal process is perhaps for us as petitioners to put forward issues, and we are happy to undertake that with as much expedition as is consistent with the interests of justice.
Issue, so that well, setting on it. Maybe by tomorrow.
Well, my lord.
Mr. Kutampa. Yeah. Mr. Chikata.
My lord.
Yeah, please, can you oblige us so that if...
My lord, I think tomorrow is a stretch because, one, I don't think we can respectfully do it by tomorrow because, first of all, respectfully, we are going to advise ourselves in respect of the ruling you've just made. We are going to take that into consideration because your ruling, as we heard it, seems to relate to the operation of CI 47. And so, since these processes of issues, they are not provided for in CI 127. Well, in the CI 99, they are not provided for in CI 99. There is no specific. So again, normally we would be guided by what happens in CI 47. But that's why we need to understand your lordship's ruling, and once we get it, I think we will know what steps to take. But I think tomorrow it will not be possible for us to submit.
Try to be a bit flexible, because if you look at the operative rules, there's no provision for amendment. But we thought it is inherent in the court of law, to be very flexible, to allow amendments. But whatever it is, if tomorrow is not convenient to you, because we thought having settled the pleadings, at least you can unearth the issues, by tomorrow, so that we set the, what do you call it, the case management in motion. Yes.
If Thursday is acceptable, by Thursday we should be able to put.
Yes, Mr. Kutampo, excuse me, please.
My lords, today was set up for case management, and all lawyers know that case management involves determining the issues for trial. And all of us should have been prepared for that. It is not acceptable that any council may suggest that when a date has been fixed for case management, especially in the circumstances of these proceedings where expedition is very paramount, to come to court and make an application that they should be given time to think about the issues. That is highly unacceptable.
Please, so it was overtaken by events because there was an application which had to be determined.
No,
yes. No. And
my lords.
Yeah. We adjourned. The court adjourns a matter. We adjourned it to today for pre-trial.
Yes.
Case management.
Yes.
Then an application was filed.
Yes.
And we thought that it was prudent on the part of the court to take the application, and we've taken it. So if we adjourn it tomorrow, we hope that you can do us a favor and file the issues. Yes.
Very well.
Because we don't want to impose the issues on you, but ultimately it's the court which will have to consider the issues which parties have filed, so that we proceed on the common.
My lords, if we can take a cue from the precedent of the 2013 petition, this matter of issues to be tried was determined in open court. So it seems to me that if your lordships are directing that we come tomorrow for that, we should come and read out our issues and for the court to take up the issues.
Okay.
Because filing these matters may take some further time.
If you prepare it in the morning, you can have it at the registry. Sorry, file it at the registry.
Very well. And also, we are just concerned that this matter be dealt with very expeditiously.
My lords, I believe that I've indicated that it would not sacrifice expedition if we had until Thursday, because we also need access to a ruling that you've just delivered. Yeah.
By tomorrow before 9:30 a.m. The case is adjourned to 9:30 tomorrow a.m.
My lords, just for clarification, I believe that beyond the determination of the issues, all other issues of case management will be dealt with tomorrow. Yes, yes.
rise.
All right, so you are watching City TV. We try to get some. How are you doing, sir?
Good.
So, okay. What are you seeking to achieve, with the there?
Well, thank you. Just to correct you, we were opposed to the application, but our opposition was on legal grounds because we hadn't filed an affidavit in opposition. So indeed, we were also opposed, much as first respondent was also opposed. Well, the real work in court has started. All this propaganda of having won 2 goals to 0. This is the first application that has formally been moved before the court. The application for a televised broadcast had already become moot because the court had already set in place the procedures for a live telecast. The application for interrogatories was dismissed outright by a unanimous panel of 7. This tells you that the petitioner has a long way to go as far as this petition is concerned. There are ground rules which have been
by implying that there has been kind of an implicit amendment of CI 47 that we think is very I don't want to use strong language, but I think that it is legally unacceptable, legally untenable. So we have requested for the ruling of the court, and we have told the court that we will advise ourselves with respect to the ruling.
Your colleague, Mr. Chikata, was asking for more time in order to get a ruling before the case proceeds. Is it your contention that this ruling potentially has an impact on the matter and how it proceeds?
That is so, and as he said, he indicated to the court that we're going to advise ourselves. So we'll look at the ruling more carefully in light of existing precedent, and then the statutes that were cited by the court itself, and then we will come back to the court to to determine whether or not we will ask the court to take a second look at its own decision.
The court said it could not demonstrate the crucial issue of relevance in the first matter. He said it couldn't demonstrate the crucial issue of relevance.
No, we didn't need to even. I think that Mr. Chikata eloquently dealt with the issue of relevance. By, for instance, taking the court through, step by step, the relevance of each of the questions that we wanted the Electoral Commission, to answer. And then also, when Learned Counsel for the first respondent was on his feet, he himself pointed out quite clearly that the issues we raised were contained in their answer. And our application for interrogatories was basically to elicit answers that will lead to an expeditious determination of the matter, so that we don't have to take them to cross-examination and have a lengthy trial, as you saw in 2013. And that is why we wanted to narrow down the issues and make sure that, when we next time we are in court, we are dealing with very specific factual matters before the court.
We spoke to your colleagues on the other side. We spoke to your colleagues on the other side. They make the point that you don't need a ruling to proceed, and that they believe that you don't want an expeditious hearing.
No, we are committed to an expeditious trial. In fact, our application, on the contrary, was the one that was designed to lead to an expeditious trial. And we are very ready for this trial. They should not, they thought this was going to be a walk in the park. And what they saw today is just a tip of the iceberg. Thank you very much, ladies and gentlemen.
So we have Dr. Dominic Ayene, part of the legal team of the NDC, essentially justifying why they filed, they were asking those 12 questions to be essentially allow them to ask the commission, to answer those questions. But then the court essentially threw out that application there, and they have been asked to return at 9:30.
application. It is not fixed in law or cast in stone that once you make such an application, you are granted the application. So it is part of the what the lawyers will call the discretionary remedies, something that is up to the court to decide whether or not to grant. Well, if you watch the demeanor or the posturing of lawyers for the first and the second respondents, it is that the petitioner is deliberately trying to delay the process. But Mr. Chachu Chikata has taken very strong exception to that, indicating that they do not or would not want to compromise justice for speed, sacrifice justice on the altar of speed, that because they want to see an expeditious trial, they end up overlooking the very key processes or issues that would ultimately sacrifice or compromise justice, which is what his side is after. And so we expect, from this language that in as much as the petitioner would also want to fast track the process or see the process fast tracked, it would also want to ensure that he is done right, justice is done by him, and that he is not denied. Indeed, one of the key questions they have raised, as in the petitioners have raised about the ruling of the court today, is the seeming departs from its own precedent. You see that the Supreme Court set a particular precedent in the 2012 petition, and it seemed to have departed from that particular precedent. Of course, it is not to say that the Supreme Court cannot depart from its own decision.
They were expecting that based on precedents, they will also allow, as they did in 2012 for Nanado, for them to also introduce their 12 questions.
Exactly, that was the confidence. And when I spoke with you earlier, I said that based on that precedent, the petitioner was confident that they were going to get the application granted them. But of course, it turns out not to be so. And so as it stands now, we are expecting Mr. Chachu Chikata and his team to, number one, receive the ruling as they requested by close of the day. In fact, they've been given express directions as to how to obtain it by close of day. And again, we expect the parties to file the issues by 9 a.m. tomorrow, and by 9:30 in the morning on Tuesday, we expect the Supreme Court to be back to continue with the pre-trial concerns, case management.
So now the way has been cleared essentially for proper case management to begin after this application, was.
Indeed, this is all part of it. This is all part of the initial concerns that must be addressed within a case management system or a pre-trial conference, as we keep saying. And so, the determination of the issues is part of it. It's just that they couldn't do that today. But I'm sure that once those are filed Tuesday morning, the court would sit again. But we cannot also discount, a possible response from Mr. Chachu Chikata. I mean, we know him when it comes to these things. I'm sure that once he studies the ruling, we should